Viewers, welcome to the weekly episode of the Law Lab podcast. My name's Tony Carbone. I'm the managing partner at Carbone Lawyers. Today I've got John Carrance as accredited specialist and senior partner at Carbone Lawyers in litigation, work cover, TAC, the whole gambit, John.
Thanks, Tony. Hi, Manny.
And Manny, a senior associate at Carbone Lawyers, litigator, public liability, commercial litigation, a bit of everything, eh, Manny?
Yeah, that's right. Tony, John, how are you today?
Viewers and listeners, we've got a very, very interesting topic about public liability. Now, by public liability, I mean you could have fallen over in a supermarket, in a cafe, in a restaurant, at the cinemas. You could have tripped. You could have fallen. You could have got injured at the gym. You could have slipped over at your doctor's surgery.
Oh, yes.
You could have fallen over at someone's house. It covers all of those. It's part of the Wrongs Act, John.
In any public place, Tony.
Yes.
An injury occurring in any public place.
Exactly. Now, Manny, that makes a big part of a lot of cases in our system. But there's some very intricate rules around that, isn't there?
Yes, there are. So for starters, the injury needs to be a significant injury in the sense that you need to establish a 5% whole person impairment. So what we ordinarily would do is send our clients to an independent medical examiner to obtain the certificate of assessment, which then allows us to launch proceedings for non-economic loss and also for economic loss. So that's pain and suffering, economic losses, gratuitous care, and so on and so forth.
John, the thing about what's critical is this. Most of these cases revolve around pain and suffering and loss of enjoyment of life. The 5% certificate Manny was talking about, or 10% psych, is really for the pain and suffering component, correct?
Exactly. Tony, we're talking here about, injuries that have a substantial impact on your life.
Yes.
Not a minor injury. Forget about a minor injury. Something that is long-lasting and is affecting your life.
Yes.
Now, if you have suffered an injury in such circumstances where it's not your fault, you should give Carbone Lawyers a ring and we'll, for free, assess whether or not you have a claim.
Yes. And the thing you've got to remember is this. A lot of the time, when you get your certificate for more than 5%, or if it's a spinal injury, it's only 5%, or more than 10% psychiatrically, what's critical is the defendant, the person you're trying to sue, can and will send you off to a medical panel. So I always found it important that when you go to doctors complaining of, say, I fell over and injured my back, get them to document all your symptoms, and in particular, you might be taking medication that causes reflux, or you might have a sore knee, or you might have damaged your shoulder. You must document all your symptoms because symptoms could develop into injuries. Isn't that correct, John?
Totally, Tony. The doctor must be aware. You must tell the doctor what you're suffering.
Yes. But by the same token, don't go there complaining of things that are totally irrelevant. Isn't that correct, Manny?
Yes, that's right. So it's just important that if you do happen to sustain such an injury, you get the right medical treatment, you go to your doctor, and you always remain honest about the injuries that you've suffered so that you've got essentially that medical evidence to support the injuries that you actually have sustained.
So this is how it works. If you've lost income, you can automatically sue if you can prove fault. If you've got medical treatment, you can sue for that. However, if you're trying to get pain and suffering and loss of enjoyment of life, you need your certificate for 5% or more than 5%, depending on what the injuries are, or 10% psychiatric injuries. Now, gratuitous services, what are they, John?
Tony, it's where someone, your loved one, your partner maybe, for example, is taking care of you, doing stuff for you at home that ordinarily you would do, as in for the cooking and cleaning, for example, but now you can't.
Yes.
And your partner is doing that for you instead.
Exactly.
As a direct result of you suffering those injuries.
Yes.
Those injuries stopping you from doing your daily activities.
Of course. And Manny, there's a threshold.
There is, yes. So you need to be able to show that you've essentially amassed 6 hours per week over 6 months in order to claim those gratuitous services.
And the beauty of it, if you can get it, viewers and listeners, is that once you get past your 6 hours a week for 6 months, and you should keep a diary and tell your doctors, it should be documented in their notes, you can then charge those services, and this could be your spouse, your children, or people doing bits and pieces for you. Let's say, I'll give you a good example. A little old lady falls over, fractures her wrist. she can't shower. So the daughter's helping her shower, helping her groom, all of these sorts of things, vacuuming, washing, cleaning, even doing her shopping. She kept a diary, lists all the hours that they've spent. In her case, it was 10 hours a week. Over 6 months, in fact, it was indefinitely, John. So, in effect, we're claiming those 10 hours a week at $32 an hour.
Oh, yes.
It's a pretty valuable right, isn't it?
Well, in the matter of Bucic, Tony, the judge awarded over $200,000 in...
I think it was almost closer to $3.
Yeah.
It was a massive figure.
Exactly.
Yeah.
Oh,
and
yes.
the reason the courts do it, viewers and listeners, is that if you had to hire an independent person to do everything that your family members or loved ones are doing, you'd be paying more than $32 an hour, don't you think?
You would think so, Tony. And it's, as Tony and John have said, it's one of those things that if you do amass those hours, it can really amount to a really big part of your claim.
Oh, it's important. But, Tony, we should address an issue which a lot of clients don't think about, fault.
Yes. Look, I was going to get to that. One of the things you've got to be careful of is you've got to preserve the evidence. So if you're falling over on a pit in the road, because the road rules are a lot different. They're a lot harder.
Oh, yes.
You need to show that if you're falling over in a pit or on a footpath, that there was work being done on that road, and they call it misfeasance. Now, we're talking back old England, guys, and if you can't show that they were doing works and didn't do it properly, you've got no rights, have you?
Tony, you have to show that there was something untoward, something dangerous that basically you can say it's because of the fault of that which caused my incident, which caused my
It could have been liquid on the
injury.
floor, could have been a banana peel, could have been a grape, it could have been or a cracked tile, could be anything.
And this is where you need to preserve the evidence, as in
take
take a
photos.
photo, to have witnesses,
Take
take a video, because clients, viewers, if you can't show that it was the fault of someone else, if you can't show that your injury was because of someone else's fault, you don't get compensation.
Exactly. And I had a case many years ago when someone fell over on a liquid, and I said to him, put away your trousers, don't clean them. So we kept them, and it showed the stain on the trousers when they hit the ground.
It helps to prove the evidence.
Yeah.
For sure. And you really can't emphasize that enough, that once the scene is there, you really do need to preserve that evidence, because you can't go back there and then take a photo of the liquid spillage on the floor, for example. It is gone. And so you do need to substantiate that. And it's one of those things that, immediately after you've been injured, you might not be thinking to actually take a photo or to take the details of an unknown witness. But it is important that you are thinking that far ahead so that we can prove liability on your case when it does get to the point of a mediation or even a trial.
At the very least, us lawyers refer to it as an arguable case. You've got to have an arguable case in fault.
Arguable case. And of course, a lot of times the injuries speak for themselves.
Of course.
And Tony, in this civil jurisdiction, we only have to show on the balance of probabilities that the event, that the injury occurred and that the fault was breached by the defendant.
Yes. Look, the thing is this. Once you've got your certificate, you issue proceedings, you might get sent off to a medical panel, correct?
Yes.
The
defendant might send you to a medical panel. They've got 60 days from receipt of the certificate of assessment that we obtain in order to then launch proceedings. And very often, as Tony has alluded to, they will send you to a panel, and there'll be a panel of expert doctors there essentially assessing the injuries according to
Could be 2 or 3 doctors.
And it is a lottery, isn't it, guys? It's a lottery.
Oh, look, it's 2 or 3 doctors, and they can make their decision, and it's final and binding. At the moment, as you know, Tony, under the COVID virus, that the medical panels have been suspended, and there's no medical panels appointments at all. So therefore, a lot of these claims actually have been literally put on standstill.
Yes,
but we can still proceed with the preparation.
Look, I'm not having a crack at the panels, right? But the reality is,
why would we?
Let's say for argument's sake, they see 1,000 people. The reality is your presentation is going to be very critical to whether they accept what you tell them.
Always.
A lot of people get in there and try and exaggerate or embellish.
No.
And it gets them offside.
Totally.
You know what I mean? And in those circumstances, there's a real prospect that they could find against you. Human nature kicks in.
Correct. Credibility in a legal proceeding is one of the most important things. And injured persons, they'll be seeing a number of different doctors. And if you're not honest, the theory, the story just really won't stack up. Honesty and transparency is one of the most important things.
The medical
in any
panel,
proceeding.
just like any other independent expert, Tony, will assess the paperwork in front of them, and they'll have all the medical reports and all the clinical records.
The person, perhaps.
But then the medical panel will want to hear from you, the injured person, how you were injured and how it affects you every day. If you can't explain that, the medical panel will have a hard time finding in your favour, Tony.
And impressions mean a lot too, because sadly, they'll probably only ever see you once.
They will.
So if you walk in there, and you turn out and they get the wrong impression.
If you can't explain your story, well, the medical panel's not going to take care of you.
You don't want to get in there looking like a scallywag or behaving like a scallywag, because you just don't know, you might get people offside. Look, having said that, you get past that process, you get your certificate, right? Then you go through your interlocutory steps. Interlocutory means the processes and steps prior to getting to a hearing. You do your discovery where you exchange all your documents, medical reports, not medicals, tax returns, etc. And then at some point in time, you'll have a mediation. Correct, John?
Yeah, exactly.
And that becomes very important because guess what? 90%, Manny, of those cases do settle at mediation, don't they?
They do, and that's where it's really important for us as the legal advisors to make sure that we're fully around the case. And by the time that it gets to a mediation, we would definitely be in a position where we know a lot more than the injured person. So it's an important step in the process. And as Tony has mentioned, most of these cases do settle at mediation. So that's what we work towards. But of course, always knowing that the matter might not settle, and we prepare for trial, which is what we do.
And John, the thing about trials, I mean, you've been in the system 25 years. I've been in it over 35, right? Sadly, when I started in the law, a day in court was $2,000 a day. Today, what are we talking?
Oh, Tony, in a county court, you're looking at easily $20,000 a day.
Yeah. So look, realistically, ideally, you'd like to settle if you can, because if the case were to go off the rails for whatever reason, or you have a circumstance where the defendant puts an offer in writing and you get less than that,
well,
then it's total mayhem, isn't it?
Exactly. The costs are prohibitive in running trials, and a lot of these trials can run for 2 weeks, Tony. But at the same time, if you've got a good claim and a good case, well, and if they're not offering the right money, well, it's a different story. But we are here as your legal advisors to advise you of whether or not you should resolve the case, you should proceed.
Yep.
You have to trust your lawyers. And
also, John and Manny, what's really critical is putting an offer of compromise to the defendant, because if you can do it right and get the figure right, and you go to court and you get what they call indemnity costs, that helps.
Well, that helps your case. That protects your position.
Yeah.
Correct. A good lawyer will put in place strategies to ensure that the costs position, if it does go to trial, is not, the $20,000 a day essentially resting on you. Indemnity costs means that you can essentially recover most of your costs from the defendant, from the other party.
Not all of them. There's always shortfalls.
Correct.
There's a lot of shortfalls.
There's a lot of shortfalls.
But we do put in place measures to try and make sure that the trial is
protected.
Correct. Protection
John,
measures.
What's critical is that at Carbone Lawyers, we've got a track record of running these cases. We probably run more cases than most law firms in Victoria.
Between you and I, Tony, we've run a lot of cases.
And the reality is, if you've had the trial and litigation experiences, you know what to look for and you know when to pick a battle or when to resolve. Correct?
Exactly.
And also, what's important for the viewers and listeners is that you've got to listen. You've got to actually take advice. When you've got someone with a lot of experience that's been in and out of battle, you've been at war every day, and we're telling you should settle, there's a reason for that. And if we're saying to you should run it, there's a reason for that too. But listen, it's your case. We advise. We can't tell you what to do, correct?
No, we only advise.
Yeah. And Manny, is there anything else you'd like to add? Because we've covered off on the main points, but short of contacting us and getting one-on-one, commentary and going over your case, you can't beat that, can you?
No, definitely not. Look, as I think we've covered, it's important that you preserve the essentially the scene of the incident. Make sure that you get your evidence and also witnesses, photos, and that you seek medical treatment, relatively soon after the incident occurs, and that you just follow the procedures and the processes. At the end of the day, as lawyers, we act on our clients' instructions, but as John and Tony have said, we advise our clients and we try and do that in order to get the best possible outcome in these cases.
What we can emphasise, Tony, is we're here to help. We're here to help with your claim. We know that your life has been markedly changed because of this injury, and we're here to get you the best result we can. And you have to remember, you only have one shot at this.
And what's the number, John?
1-800-369-888.
And viewers and listeners, on that note, thank you for watching and listening. Thank you, Manny. Thank you, John.
Tony.
Thank you.
Stay tuned for future episodes. Viewers and listeners, go to our social media sites, Twitter, Instagram, Facebook, YouTube, you name it. We got the whole gambit. Anyway, stay tuned and please stay safe in these very challenging times.
Admittedly. Don't settle for less. Cowboy Lawyer.